We are continuing to keep a close eye on the John Edwards corruption trial. The prosecution calling lots of witnesses to the stand over the past 3 weeks. But as they prepare to rest their case, prosecutors say they won't be calling on the woman at the center of it all, Rielle Hunter. So what's the strategy behind this? Our legal panel joins us now. Former federal prosecutor Doug Burns, also criminal defense attorney Chip Merlin. Doug, the prosecution decides they've done their case. A lot of people speculated that they didn't have enough to make the charges stick. They apparently think they do, and they don't need Rielle Hunter to help make that case.
Well, that's true, and I also think, John, that they see some potential downsides with Rielle Hunter. You know, she's sort of like that snake you look at and you got to be careful of. While theoretically she could help their case on some level, she could also backfire, and I think that's the calculus they're engaging in. As far as their view of their own case, my position is they think, the prosecutors, that they've improved their lot in this trial. I think the reason they feel that way is that the jury dynamic is bad when a jury views a defendant as somebody who's engaged in a pretty massive cover-up, has lied about what went on. The checks, after all, at issue were made out to a furniture design company, and all of those sort of indicia and badges of covering up kind of make these prosecutors feel as though they're in good shape. The other huge point, I think, which I saw yesterday, is I think the prosecutors think that once John Edwards' wife learned of the affair, any movement of money after that point is clearly tied towards the campaign and the election. So I think that's what they're staking.
Right, because he had been arguing, or his side has been arguing, that it was really just about trying to cover up the affair, keep his wife from learning about it, not the general public. Chip, what about it, though? She could still testify on behalf of the defense. Would that be a wise move?
Well, we don't know, and I don't think the defense knows either, because throughout this entire matter, everybody's been concerned about what Rielle Hunter is going to say. As a matter of fact, a lot of this hush money was because nobody knew exactly what she was going to say. They kept transporting her all over the country, as a matter of fact, to keep your enemies closer, I think was what the quote was at the trial. So I don't think the defense, it's possible they could. I actually kind of doubt it. I don't think she's a very material witness to this case.
And in your view, Doug, the prosecution, which, again, a lot of people thought had a pretty weak case at the beginning, seems to have turned a corner.
No, that's what I was saying, John. You know, you look at a trial like an empty swimming pool. I'm not trying to be funny, you know, and as you fill it up towards that reasonable doubt line. And I think that, you know, jurors also, they're very smart and they keep things very simple. And, you know, Chip knows this. In other words, we lawyers engage in, you know, very, very high amounts of minutia and thinking and strategizing. But jurors are like, wait a minute. Did he try to hide this? Did he try to cover it up? The answer is basically yes, from everything I described earlier. And then they say, did he do it just because of his wife, or was he doing it in connection with the campaign? And they keep things simple. And that's why I think they've improved their case.
Yeah, and Chip, Jennifer Palmieri, the former speechwriter, was apparently in tears on the witness stand yesterday, recounting a conversation that she had with the late ex-wife, Elizabeth Edwards. That can't be good for his case, just all of the sympathy directed toward Elizabeth.
Well, in front of the jury, obviously the sympathy part is not going to be in John Edwards' favor at all. An affair is bad. Paying a mistress to keep quiet, that's bad. Everybody knows that's bad. But the prosecution has to prove that John Edwards violated the letter of the law. And in this particular case, the letter of the law is very technical federal election standards and laws that are very questionable if they've been broken. Does this qualify under the law, the giving of, quote, money to a mistress to keep her quiet, as a campaign donation or a campaign expense? And they're arguing, the lawyers for Edwards, that it doesn't as a matter of law. The law could have been written that way, and maybe this is bad, but he did not break the letter of the law and didn't do it willfully either.
Well, happening now, the suspect in a 33-year-old murder mystery is reportedly on suicide watch. Pedro Hernandez is his name. He's expected to be arraigned today. Despite that, New York City police say he confessed to killing 6-year-old Eitan Pates back in 1979. It's still hard to see those darling photos of this little boy. Apparently, the confession says that Hernandez strangled this little boy just a few steps from his home. We're not clear on the motive. In fact, we're not clear on a lot of details on this except for the confession, which we're starting to hear more about. Former federal prosecutor Fred Teese is with us, and defense attorney Chip Merlin, the founder and president of Merlin Law Group. It is hard to see those photos still. I mean, we've seen them so many times, Fred, and it just, the loss of a child, it never gets any easier, even to talk about. And I just wonder for the family, what's going to happen next? I mean, what are the steps? We have a confession from someone, but as far as actual evidence, we don't know what we have. So what is next?
Well, we don't know what we have, Jenna, and you're absolutely right. You know, and if you've heard me say, I've got 4 sons. My youngest is 10 years old. I mean, I look at that picture and my heart just breaks for this family who never moved and never changed their phone number in case their little boy came back for him. But to answer your question, what's next is he's going to be arraigned on second-degree murder. And I've got a lot of questions about what's going on here. I mean, what physical evidence do the police have that corroborates this guy's confession? You know, what do they have that makes them believe that this isn't just some guy who's decided to confess to this murder?
And Chip, on that, you know, if you were the defense attorney, you know, and this was your client, is there even a strategy? I mean, do you just take this confession as the truth? Or are you also concerned that maybe this guy's some crazy guy that just decided that he's going to make this confession?
Well, confession might be good for the soul, but it makes the job of the criminal defense attorney very difficult. New York has a very interesting law, though. It says that a confession all by itself, without some evidence that an actual crime took place, is not admissible. Right now, there is no body, there's no corpus delicti, except for the individual's confession about how it happened. There is no physical evidence, and that confession might not be able to come to the courts in New York because of this very particular law that New York has.
So then what? I mean, then what, Chip? What does that mean? He would never have a trial?
No, that's the reason why the continued investigation is so extraordinarily important in this particular case. The police are going to go back after looking at the confession and see if they can find some type of corroboration that the way and the manner that this confessed murder took place actually did take place that way. Without it, that confession doesn't come in.
So, Fred, if the confession does hold up and there is somehow some evidence, and again, we have limited information right now about what that evidence could potentially be, what would this man face? Would he face the death penalty?
Well, in 1979, when the crime took place, New York didn't have a death penalty, as in a lot of other states would have been struck down after Furman versus Georgia. So I think that's off the table. And he's been charged with second-degree murder, which, unless the state can show that the murder was committed in connection with a sex crime or a rape or sexual abuse, and the victim was obviously under 14, then the charges, believe it or not, the penalties are 15 to 25 years imprisonment. So at the end of the day, you know, the state has to do more. And if you believe this guy's testimony, Chip raises a great point. I don't know how the state corroborates it. He says that he strangled a little boy, put him in a bag, and then disposed of the body in a basement that's been there for 33 years. I don't understand how the state corroborates that, and I think this is a tough case for the state to begin with.
So could he walk free, Chip, even if he has this confession that apparently is so thorough, but there's no evidence? Is that a real possibility that this man maybe never serves any time behind bars?
Well, it is a real possibility in this case if they don't find the corroborating evidence. And just remember, in the DNA evidence, which we don't have in this case, we have found that after false identity, the number 2 thing that people get off the hook off once the real DNA evidence comes in is their own confession. So this is pretty important, and the reason why New York law requires that there be some type of corroboration other than the confession itself that this is the way it happened.
Wow. Guys, it's so interesting. And you just, again, going back to the family, you just want some justice and some resolution for the family. And you wonder if they're really going to get it here or if they ever can. Fred and Chip, it's nice to have you. As we learn more, we'll have you both back. Thank you.